5 seconds to go. Start. In Pankaj Bansal Supra, one of the contentions raised by the DOE was that the legality of arrest is rendered immaterial once the competent court passes an order of remand. Reliance was placed on certain judgments. However, these judgments were distinguished on the ground that they primarily addressed writs of habeas corpus following remand orders by the jurisdictional court. Therefore, the ratios therein are not applicable to this scenario. In the context of statutory compliance, the court observed in clear terms that if the arrest is not in conformity with Section 19(1) of the PML Act, the mere passing of an order of remand in itself would not be sufficient to validate the person's arrest. Thus, notwithstanding the order of remand, the issue whether the arrest of the person is lawful at its inception is open for consideration and must be answered. Recently, in Prabir Purkayastha versus State and City of Delhi, this court reiterated the aforesaid principles expounded in Pankaj Bansal Supra. The said principles were applied to the peri materia provisions of the Unlawful Activities Prevention Act 1967. The court explained that Section 19 of the PML Act is meant to serve a higher purpose and also to enforce the mandate of Article 22(1) of the Constitution. The right to life and personal liberty is sacrosanct, a fundamental right guaranteed under Article 21 and protected by Articles 20 and 22 of the Constitution. Reference was made to the observations of this court in Roy V.D. vs. State of Kerala that the right to be informed about the grounds of arrest flows from Article 22(1) of the Constitution, and any infringement of this fundamental right vitiates the process of arrest and remand. The fact that the charge sheet has been filed in the matter would not validate the otherwise illegality and unconstitutionality committed at the time of arrest and grant of remand custody of the accused. Reference is also made to the principle behind Article 22(5) of the Constitution. Thus, this court held that not complying with the constitutional mandate under Article 22(1) and the statutory mandate of the UPA on the requirement to communicate grounds of arrest or grounds of detention would lead to the custody or detention being rendered illegal. In Vijay Madan Lal Chaudhary and others versus Union of India and others, a three-judge bench of this court distinguished between the stringent requirements stipulated in Section 19(1) of the PML Act and the power of arrest given to the police in cognizable offences under Section 41 of the Code. Any police officer may, without an order from a magistrate and without a warrant, arrest any person who commits in the presence of a police officer a cognizable offence against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offence punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years, whether with or without fine, if the following conditions are satisfied, namely, the police officer has reason to believe on the basis of such complaint, information or suspicion that such person has committed the said offence. Stop.